Ladies and gentlemen, I welcome all to my channel. Today let us discuss about two terms, preventive detention and punitive detention. Punitive detention is a criminal proceedings detention for the as a punishment to the accused. Whenever a person commits a wrong, supposing a person commits a murder or dacoity or he is involved, spoil the public on cause law and order situation and break the peace. In that case, in criminal case he will be arrested and he will be detained for the criminal proceedings. This is called punitive detention. So supposing the court you pass any judgment and give a imprisonment for 1 year, 2 years, so that is also punitive detention, and this is the punishment. The detention is made on the basis of the punishment or judgment given by the court. In some cases, some of the acts like MISA, Gundas Act, COFEPOSA Act give some powers to the some specific authorities to pass an orders to detain any person under the as per the rules and regulations of the particular act. That type of detention is called preventive detention. The motive of this preventive detention is whenever supposing the government officers feel that if a particular person is left is not prevented by detaining in the prison, he will involve in a crime, he will commit crime. His commitment of crime, his proposed commitment of crime or his proposed criminal activities cannot be curbed without being detained in the criminal without a preventive detention order. In such cases, the concerned authorities will refer the matter to the minister or the specific authorities referred under the act. Then the concerned authorities will pass a detailed order specifying the grounds for the preventive detention, and they may detain the person for 1 year or 2 years depending upon the nature of the case. So COFEPOSA Act empowers the authorities to pass any preventive detention whenever a person regularly commits smuggling and involved in the violation of customs for foreign exchange violations. Similarly, Gundas Act also empowers the authorities to cause preventive detention whenever a person repeatedly commits crimes mentioned in those Gundas Act. So this is the difference between preventive detention and punitive detention. So whenever a preventive detention is made, then the one and only remedy available to the accused person is they have to file a writ before the High Court or a writ before the Supreme Court, and they have to challenge the preventive detention, saying that their detention was made as against the Constitution, the principles of natural justice is not followed, or the order was passed without applying proper mind. The delay was caused. Delay in whenever supposing a person gives a representation that our representation was not considered properly, the representation was considered in time, there was a delay in consideration in the representation, like that, under various grounds we can file a writ petition before the High Court and we can struck down the detention order. Regarding the punitive arrest is concerned, one person can apply for a bail, or supposing the conviction is made, then the aggrieved person can file an appeal and get the order set aside. Thereafter they can come out of the jail. This is the difference between preventive detention and punitive detention. I hope this video will be useful to you. You can watch my channel. Raziaq LawTube is my English channel. Raziaq Sattam is Tamil channel. In addition to that, if you have any specific doubts, you may also contact this cell number. If time permits, I will try to clarify or give necessary legal advice. Thank you. Goodbye.